Mic check. Hello, everybody, and welcome to the stream. We'll get started here in just 1 second. Get this other earpiece in. Okay, so it's not going to be a very long live. I just kind of wanted to go over the steps in the process since Lehua and Isaac have been arrested. They've had grand jury. They've been formally charged with the charges that they have. Um, hey, Hodani. And the reason I decided to do this little live is because I don't know, mainstream media, whenever they present these cases, they always make it seem so scandalous, like when the person pleads not guilty at their first appearance or whatever. But it's really not a scandalous thing. It's just a part of the process. Most of us who follow true crime, we know that it really doesn't mean anything, and especially not this early on in the case that people are pleading not guilty. But some people may have just come into the true crime realm with this case. They might not even be familiar with how criminal courts work or whatever. So I was looking at some stuff and I found a flow chart for felony cases in Hawaii and how that whole process works. And so for those who are new to true crime and the way the process works, I hope that this video will just be helpful for you. Um, and for those of us who have been following true crime for a long time, I hope that it'll be helpful to you. Maybe it'll be a refresher, just remind you of some things. I will put the link for this flow chart in the description because it does have some good, it defines a lot of the terms that are used around the court process. And so I think it'll be helpful for people to be able to just go and check that out whenever they want to. So here we go. Adult felony cases, and this is for Hawaii. You see here where it says refer to Hawaii revised statutes. So in adult felony cases, it starts with an offense being committed, and then the police get involved. Now for the next steps, with the Kaluas, we kind of have a hybrid of what the next steps are, because here you see that it's broken down into after the police get arrested. If there's one of three things that happen, either someone is arrested, there's an arrest pending an investigation, meaning they arrest someone, but they're investigating whether or not something happened or what actually happened in in the process, basically determining if there is a cause to bring charges. And then there's also not arrested. Okay, here is where the kind of hybrid or overlap comes in. We know that Lehua and Sonny were not originally arrested, like when they called to report Ariel missing. We also heard Sergeant Tomez, if I'm saying her name right. We heard her in a recent press conference saying that they were really suspicious of foul play very early on. But even though they were suspicious, they didn't actually arrest um, anyone yet. They were still investigating. So here's where the hybrid overlap comes in. All right. They were not initially arrested. Police investigation and referral to the prosecutor. Someone donated Someone donated an additional $4,000 to the reward for info on Ariel's disappearance, making the reward $15,000. I hope people come forward now for the Kaluas. Now forward, now the Kaluas are in jail. Okay, that is excellent. I am so glad to hear that. That is like really great news. I really hope that um, someone will come forward. We really need to find this baby. Just give her a proper laying to rest. Like somebody really needs. I'm gonna pin that up there. Maybe somebody will, slide by the stream and see that, and hey, I need that $15,000. So we'll just pray for that. Okay, as I was saying, they weren't originally arrested. The police were doing an investigation and a referral to the prosecutors. Well, we know that they were investigating anyway. They were gathering information, sorting through what they found, and deciding whether or not there was a need to arrest them and on what charges or whatever. Now, once it goes to the prosecutor, if the prosecutor feels that there is insufficient evidence, then they won't prosecute. And basically, in this case, if it had just been the police saying, "Oh, we think they killed her," but they didn't have like this circumstantial evidence that they have with Ariel not being seen on camera since the 18th of August, or the testimony from Big Sister, the prosecutor wouldn't have pursued charges, because you can't just arrest somebody because one person thinks they did something. Then it would have gone to the grand jury. And what the grand jury does is they look at all the information that the police have gathered during the course of their investigation. And that grand jury, even though they're not really deciding guilt or innocence, they're deciding if it makes sense to charge this person. Basically, they decide probable cause. It's kind of a redundancy, because the prosecutor has already decided, yes, there's probable cause, so we're going to send it to a grand jury. So it's really just kind of confirmation that yes, you have enough evidence. This is why I think this link to this is going to be really helpful to people, because it has some definitions in here. And for probable cause, it says such a state of facts as would lead a person of ordinary caution and prudence, in other words, just your average everyday person, that would lead a person of ordinary caution and prudence to believe and conscientiously entertain a strong suspicion of guilt of the accused. In other words, based on what you know, what you have in front of you, and what you can see and tell, does it seem like this person did this crime? Well, either the grand jury will say, no, I don't think there's enough evidence for this, which would result in not indicting them and no prosecution. But in this case, the grand jury said, yeah, we're going to indict them. We feel like there's enough evidence that says they're most likely guilty of something. So they got indicted. Now, had they not been arrested, at this point, a warrant would have been issued for their arrest. But as we know, they were arrested before they went to the grand jury, which is why in their case, we saw an arrest followed by the process of whether or not they're going to get bail. Okay. In their case, the prosecutor had already approved the charges. A judge made a preliminary determination of probable cause. And the bail, we saw that they didn't get that. So they're remaining in custody. We saw their initial appearance and setting for preliminary hearings. Preliminary hearings, basically, it says a process in which the judge determines whether there is probable cause to determine that the defendant committed a crime. So again, another layer of redundancy, because especially on like charges as serious as murder, you want to make sure that you are putting forth, at least that's how it's supposed to go in the criminal justice system. You want to make sure that you are prosecuting someone fairly, that it really is something they need to be in custody for, facing trial for, or whatever. Hence the many layers of redundancy and seemingly just stuff that is extra and really probably doesn't need to be done. Truth is, it really does. Um, Now, in either case, they're in custody. So next, we're going to go to arraignments and pleas. And arraignment is basically when you're formally, officially told what you're charged with. Now, when you go to your first appearance, the first appearance is after you're arrested. I believe in most places you're supposed to see a judge within either 28, 24, or 48 hours. And that is to tell you basically, hey, we've arrested you. This is why you've been arrested. And the judge will set an initial bond and say, hey, well, either you're not entitled to a bond or you can get out for this amount of money or whatever. And that's your first appearance. Usually on misdemeanors, that's also a time when defendants could just plead guilty or no contest and get sentenced right there. And you might see a lot of that in misdemeanor cases. However, with felonies, usually a not guilty plea is automatically entered at this point because felonies are serious and they carry up very severe penalties. So you don't really want to um, just accept a guilty plea off top. And I'm not a legal expert at all, guys. I'm not a lawyer. I'm not a judge. I'm none of that stuff. I'm just somebody just talking common sense. And I read the stuff and I just break it down to what common sense people would say. So you don't really want to accept a guilty plea at this point because you never know. The person could be emotional and just having a bad day. And, I don't care. I'll just plead guilty or whatever. um, it might turn out that there actually isn't enough evidence against them. And then they pleaded guilty to something that they may not have even actually done or whatever, or you can't prove that they did it. So a not guilty plea at this point is really nothing to get all worked up about. It's just a step in the process. An arraignment that we were talking about, arraignment and plea. Arraignment is a hearing at which the defendant is formally notified of the charges against him, and at which time a plea of not guilty, guilty, or no contest is entered. If a not guilty plea is entered, the case is given a trial date. Usually at this phase, even though it's probably going to be several months down the line, it's still going to be a not guilty plea. Because in the case of felonies, there's just like so much paperwork that they have to do. And I'm going to pull up a case from my hometown to show you kind of an example of that. Right here, you'll see. Now this is the case records for Robert LaTroy Howard. Um, he was accused of and recently convicted of the kidnapping and murder of a 12-year-old girl in my hometown. And you can just see from this, all of these records are just different steps in the process, different things that were done. It took 4 years from the day he was actually more than 4 years from the day he was arrested to the day he was finally convicted. And all of this was just steps in the process. And you can see where he had his initial first appearance in front of the judge. There were search warrant affidavits filed, police reports done, bond hearings. Most of that was done at that first appearance. You have an arraignment set that says going to be that formal formal notification of the charges. But in between, you'll see you have all kinds of stuff going on. You got notices of discovery, notice of invocation of constitutional rights, more search warrants, the actual indictment from the grand jury, um, warrant issues that were addressed. And so you have all these different things that are going on. And that first appearance was in June of 2017. He was just sentenced in, I think I want to say September, yes, September of 2021. And over the course of this, his lawyers were filing a lot of motions. The state was filing a lot of motions. There was one particular motion, which is why I even thought to pull his case up, was because an example is another reason why you get a not guilty plea off top. Well, his attorneys in his case filed a motion because he confessed. When he was first arrested, he ended up confessing. Well, his lawyers tried to get that confession retracted. They tried to argue that it was coerced, that he was sort of threatened, that the police implied promises to him if he would confess. So you have a lot of wrangling back and forth where each side is trying to set the stage so that trial is more favorable to them if it comes to a trial. The defense is going to file motions to keep evidence out that says, hey, this person is guilty. They're going to argue that, hey, my client is not competent. They're not emotionally stable to be held responsible, or whatever else they can argue to set the stage to make it better for their client at trial. The state, on the other hand, is going to argue they're going to do the best they can to make it good for the state and easier for the state to prosecute this person and get a guilty conviction. They're going to bring in opposing experts. You know, if the defense says, hey, not mentally competent, the state's going to say, hey, I got an expert over here that says they're fully in charge of their senses. They knew exactly what they're doing. But back to the flow chart. All right. Now, if after arraignment or at arraignment they wanted to plead guilty or no contest, the court has the options of sentencing them right then and there on the spot, and they could be sentenced to up to the maximum of whatever their charge carries. If it's a life sentence, then they could be charged to life, sentenced to life right there. They also have a thing called deferred acceptance, which is, if you're familiar with the courts and like pretrial diversion programs, deferred acceptance is usually not an option or not something that's done in serious felony cases. But in cases where it is used, they'll say, okay, we will put this off. We will give you the option to complete these steps, these programs, pay this fine or whatever. And if you do this, then you'll get a lesser sentence, or we'll just completely do away with the charges. That's not something that you're going to see in a murder case. I've never seen it. Now, they plead not guilty. So that means that they have to have a trial. And leading up to that trial is going to be all the things that I was just talking about, the different motions, the different arguments. You're going to have discovery. You're going to have one side fighting to get evidence in or out, the other side fighting to get evidence in or out. Both sides fighting to set the stage to their best advantage. And at the trial, when we finally reach the point of a jury trial, then one of three things can happen. They're going to be convicted and found guilty, which will lead to a sentencing up to and including the maximum sentence for the charge. And I think that with the Kaluas, the maximum sentence for their charges is going to be life without parole. They could be found not guilty or acquitted by the jury, in which case the jury basically says not necessarily that they didn't do anything, but that the state did not put forth enough evidence to prove what they did to the point where the jury felt confident in sentencing these people to prison or incarceration, taking away their freedom or their rights based on what they were told in court. I doubt that's going to happen with the Kaluas. And the other option is dismissed. Dismissed is, it could be for many different reasons. And I'm not going to get into that because I'm not a legal expert, but I will read you the definition. It says the court can dismiss the case against the accused if 1, upon completion of the prosecution's case, the prosecution has failed to meet its preliminary burden of proof, or 2, if the jury is unable to reach a verdict and the court determines that further prosecution would be inappropriate. And I guess a really good example of that would be Flowers. I can't think of his first name. Let me see if I can pull him up. There was a guy who, Curtis Flowers. There he is. Curtis Flowers. Fourth. He was tried like 6 times for murders that happened in 1996, and in each case, uh, they would end up with like a hung jury, or he would be convicted, but then he'd appeal, and they'd have to overturn it, and he'd be tried again. And this prosecutor just kept trying him over and over and over until this last time, uh, when he appealed it, they overturned it. They let him out. He was out on bond, and they decided not to try him for the 7th time, which was, I'm sure, a relief to him, because basically the way it went, they really did not have enough evidence to convict the dude. Um, there was always something wrong with their case, so that was basically a dismissal. They decided not to prosecute him again, and that is the next steps that you can expect in the Isaac Elehua Kalua trial or case. I am going to get off of here. I said this was going to be just a really quick live. I just wanted to get that information out there. I will put the link in the description for this flowchart if anybody wants to use it as a reference. Good night. Thanks for joining, and I will see y'all next time.